The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today and to the virtual Court of Appeals. I'm glad we are all able to make it. Counsel, this is in the matter of Lydia Mower and Thomas Mower. And counsel, if you could please enter your appearances for the record. Appreciate that.
Yes, Your Honors. Jared Jennings and Cassie J. Madura on behalf of the petitioner Lydia Mower.
Douglas Thayer, Your Honor, and Mark Nelson on behalf of the appellee.
Perfect. I appreciate, I think I've definitely seen Mr. Thayer on a virtual hearing before. And Mr. Jennings, have you appeared virtually in the past?
Oh, yes, several times. Yes, I've done trials virtually, so I'm comfortable with that. I just, and I apologize to everyone. I apologize to counsel as well for delaying and wasting their time today. I don't know what happened with the disconnect, but yes.
All good. I just want to go over just a few ground rules for this hearing today, these arguments. Each side will have 15 minutes, obviously, in which to make its arguments. It appears, Mr. Jennings, that you have reserved 5 minutes for rebuttal. Is that correct?
Yes.
And the judges will mute our microphones while you are arguing. Unless we have a question, then we'll unmute ourselves and try and get your attention to ask our question. And I would ask that for the lawyer who is not arguing, if you could turn off your camera and mute your microphone. That helps us focus, and it also helps with the bandwidth. For whatever reason, having less cameras on helps us all. Do either of you have any questions about how we will proceed this morning?
I do not.
I do not, Your Honor.
Thank you. Then, Mr. Jennings, you may begin anytime you are ready.
Thank you, Your Honors, and may it please the court. I do not wish to belabor the point too long. It has been well briefed. It is largely this legal issue. Our chief questions are, did the district court err in ruling that the husband's death caused it to lose jurisdiction over the divorce action and dismissing it? We believe the answer is strongly yes, and for many reasons that we've briefed. We believe that the death and a final divorce decree have the same legal effect, and if the decree precedes a party's death, the claim for the divorce does not abate and therefore cannot render the wife's incidental claims moot. And we've cited to the statutory authority for that, certainly the Utah Code 30-3-7 sub 1. Likewise, the Utah State Constitution and the line of cases. Most telling, and I think the focus case here today really is the Parenta decision. Again, Parenta stands for the principle that, and essentially in many ways, resurrected clearly the In re Harper's estate case, which at one point was overruled by the Daly case, but then resurrected again by the Parenta court, citing that essentially the Daly court's comments were dictum. And obviously under the three-factor State versus Robinson analysis, it's dictum because there was no real analysis by the Daly court. The statement didn't affect the outcome of that case. And I see you raising your hand, Your Honor.
That's correct. That's because I have a question.
Sure.
And I think the Parenta case is very helpful to your position in one respect, but I wonder about another. And as I read Parenta, it seems to me to make three important points. Number one, if in a divorce action, the divorce has not yet been entered before one of the spouses died, the action is over.
Yes, but that was go ahead.
If, however,
I took a pause for perhaps an inquiry on my part. I assumed wrong.
That's my first of two takeaways from Parenta. The second is, if, however, there have been otherwise interlocutory interim orders entered, those will still be enforceable to the extent that they don't, by their very nature, abate, such as visitation, temporary alimony, and so on. But if there's been some disposition, that can be given effect. And then thirdly, and I think this is probably where we are, thirdly, if there are claims that by their nature survive the divorce, those also can be pursued. And of course, I would think all the more so here where we actually have the bifurcated divorce. We've got a divorce.
That is correct.
Now we've got property and whatnot to sort out, but we never quite got to an order. But Parenta suggests that to the extent that those claims will survive, so as to property, yes, as to alimony, no, and so on, those claims can do survive. And I think everything I've said so far is music to your ears. Here's the part that may not be.
Here's the other shoe, right?
Is also discussion by Justice Durham and the majority in Parenta to the effect that insofar as claims not otherwise reduced to judgment or an order are survived, though those may well be claims that can be asserted, that can be brought before the personal representative.
That's correct.
And I think that ends up being kind of the narrow question before us. And I don't mean to unduly simplify the argument or take all of your time.
No, I think that you're right on point. I know exactly where you're going.
Judge Griffin seemed to think, and I think he's probably wrong to a certain extent, I've lost jurisdiction totally. I can do nothing. But he recognizes that it may well be that insofar as your client has claims that survive the death of her former spouse, those can be brought to the personal representative, and those can be adjudicated as part of the estate. I did not see anything in Parenta that would necessarily say that was wrong. In fact, some recognition in Parenta that maybe we shift from divorce court to probate court to wrap up those surviving claims. So sorry for the long roundabout context, but my specific question now for you is, why is it necessarily wrong for Judge Griffin to have recognized the continued viability of those claims to be pursued other than in the divorce court, namely in the probate court?
Absolutely. And I'm happy to address that. And that's directly on point with where I want to go. So I appreciate you getting us there quickly, Your Honor. First off, this was a 16-day trial. They're incredibly complicated and numerous issues. We heard from numerous experts. Okay. And so when we start talking about the resolution of these claims, okay, many of the claims that were unresolved are things like retroactive alimony awards and retroactive claims for attorney's fees, which literally Judge Griffin had to hit print on his decision and have us show up to the hearing to get that information. It is impossible and completely, well, not necessarily impossible, but for all intents and purposes, certainly for my client's purposes, impossible now to try to have that worked out in front of a probate court, which we would essentially have to redo the trial, okay, to have those claims in any way, shape, or form adjudicated. Now, keep in mind, the retroactive alimony award was for the period of time. Let me finish my sentence. Absolutely. The retroactive was for a period of time prior to my client's remarriage. So there is an insular, locked out period of time. Okay, there.
Is it right that it would be impossible though? Because in theory, you could have the same judge be the probate judge, and in theory, I think he could take judicial notice of the evidence that was taken in the divorce court, and then he could print. So why is it actually impossible?
Yes, Your Honor. You know what? That's why I changed it from impossible to impracticable, right?
But why would it be impractical? I mean, in theory, I'm not completely familiar, I'll confess, with the Fourth District's assignment practices. But if Judge Griffin becomes the probate judge, then
if that were the case, and I think it is in probate, and I don't think he is, but if we wanted to collapse it there and send it to him, I'm not necessarily opposed to that, but there are all a bunch of priority things. And as they argued in their briefing to Judge Griffin on this issue that we were appealing, right? is that we have all these different priority classifications for claims against the estate, okay, which talks about starting with funeral expenses, cost of administration, death and taxes, reasonable expenses, medical hospital expenses for last illness, debts and taxes for preference under other states' laws, saying that they're already indicating, and their argument is going to be that my client's claims might fall into the 5th category. When I think that the more equitable, and I think that the dissent from Harper's estate is so on point here. This is a divorce court sitting here to do equity, all right? To do what's fair and what's just, okay? If we simply get that ruling, then we remove from the estate what my client's award should be from the divorce, and it doesn't fall into probate. In other words, I'm saying that she shouldn't have to now get in line necessarily with all the other debtors when there's an amount of the estate that's already hers that should be separate from that part. And it is clear that their ultimate intent there, when we're talking about an equitable standpoint, I see you, Justice Romer, I apologize, is to now then bury her in probate court. That's why I think it's impracticable. Okay, when I think the better decision is to get the actual amount there, and then I think that maybe it could be our policy to then require that if it is going to be done in probate. First off, I disagree that I think that Parenta suggested it ought to be in probate. I think that certainly the equitable cases and the dissent, which was relied upon by Parenta in Ray Harper's state, says we're supposed to be doing equity here. We should be doing justice. This court has to do, all this court has to do is print the decision and give it to us, okay? And then we can have a final order and go into, and if we have to go into probate after that, at least we go in with the decision. Okay, and already having those resolved. Go ahead, Your Honor, sorry.
The problem is under Parenta, and I think almost a matter of settled jurisprudence generally, for lack of a more precise term, the problem is that although Parenta does recognize the continued viability of an order that took care of part of the divorce, and also recognizes, well, and claims may have some continued vitality, our law doesn't recognize an almost order.
I understand, but it does say that we can have that those claims survive. It doesn't require them. There's nothing in there actually requiring it to go to probate court. And also, Parenta is very clear in saying as well that this is an issue we didn't address, that this weird circumstance we're in. And I think that equity then demands that we allow this to be completed, but with those survived claims, okay, it's going to be cleaner and clearer no matter what court it ends up in. Okay.
If we agree, hold on. If we agree that the court was wrong in concluding the death meant it had no more jurisdiction, operating under that legal error, if we agree with you on that point, it's not in the cards for us to remand with instructions for the court to hit print. It might, however, be well within the realm of possibility for us to reverse for the simple reason that the judge was operating under a mistake of law in concluding that the court did not have jurisdiction with respect to claims already asserted, and not only asserted, but to an extent litigated, and straightened around on the point that it really does have jurisdiction to see some of those things through. Per Parenta, the court needs to revisit that and enter such relief as may be appropriate. It may have to go through and say, well, that one doesn't survive death, and that one doesn't, this one does, this one does. So hitting print may not work. But if you are right that the court really did have jurisdiction, seems like we don't do much more than point out that legal error to the court and tell it to proceed anew in the consideration of those claims, with the personal representative substituted for the late Mr. Mower. What's your take on that?
I don't find that offensive at all. I will admit that I also like your suggestion, Justice Tenney, that these claims should be consolidated under the same judge. So
I made that suggestion, but okay, yeah.
But I'm saying I think that would be, if we're going to go that way, then that would be the ideal one. If the judge says, this should be dealt with in probate court, I mean, I don't think that he should volunteer another judge to fight this fight.
Can I ask you, unless you got more to say on that question, I wanted to ask you a particular question before you virtually start.
Sure.
And I recognize that you're past time, so
I am. Yeah.
In the realm of brief, but I wanted to get your take on this part of it. I thought that the most compelling point that the red brief made was the point. I've got it in my notes is really kind of being fleshed out on page 37. But the upshot of the point is, if you're right, then it's likely that the courts are then going to be proceeding on something of a parallel track, which is then going to create the possibility of conflicting rulings. You've got the probate court over here saying this piece of property goes to this guy, and you've got the divorce court over here saying, no, this is actually hers. And it's going to create something of a mess. And I understand that to be one of the really sort of driving subtexts, if not urtexts, of their point, is that you can't have these conflicting cases that are issuing conflicting rulings about the same stuff. What's your response to that?
I understand. And to a degree, Your Honor, I think I already hinted at my answer to that in the first place, that I think that the divorce claim should be resolved first, creating those separate assets from the marital estate as Lydia Mower's assets.
Let me
finish. Yeah. So procedurally, what I think would happen then is you would just have to put a stay on the proceedings in probate court pending resolution of the divorce track first, then have that happen subsequently to make that cleaner. Because you're right, it does create, but I mean, think about it this way too. What if there's a pending appeal in probate court from a decision of a judge later on? In other words, we send it all to probate court, right? We get rulings that, because Judge Griffin even said, I know that no matter what I kind of do in this case, there's a good chance that both parties are probably going to appeal my decision. Okay, well, the same thing will now happen potentially in probate court, but we're already knee deep in a bunch of other people standing in line, already potentially getting their property handed to them, distributed and paid out. Now it's gone from the estate, which becomes in divorce court. That would be that would be committing marital waste potentially.
Right. Let me ask.
Right.
Yeah. Let me ask the follow up to that, because I thought that had to be your answer.
Yeah.
And this is sort of, that would then append an answer to Judge Warren's question, which is we would then have to say that the probate court effectively has to be stayed. What would have happened though if he'd have died in 2014 then under that rubric? Because if he'd have died in 2014 and we had then had this rule in place, the probate case would have been stayed for another 4 or 5 years, 6 years at this point.
No, I don't think so, because a good part of the not at all. It would have actually clarified a ton of the claims, because a large part of the reason that this case had drug on so long was the custody and custody evaluation issues, which are suddenly gone. Okay, so you're presuming that if he died in 2014, the case absolutely positively still would have drug on another 5 years. I disagree. But that's the problem with playing what if, right?
Sure.
But
it's a bare minimum. Then do I take it that your answer to it's sort of now a combo question of Judge Orm, I'll give him credit, and me, is that we would have to say that the district court, the divorce court, still has jurisdiction, and almost by effect there would have to be something of a stay of the probate court case until the divorce case is finalized.
Right, because we still have to establish what the actual decedent's estate was, which would be sans whatever she was awarded out of that estate, which would be her separate estate. And also in 2014, by the way, she wasn't remarried then either, so ongoing alimony would have still been a claim, right? As well to be done. Not just retroactive, would have been ongoing. So, but under any circumstances, this case would have been over in 2015, I think. But so that's how I would respond. And I think the same problems, right? The same issues, the same concurrency issues, other claim issues occur if we send all of these issues then down to probate court. But now she's got to, and by probate preference rules now suddenly compete with other creditors, when there is absolutely a potential issue here that, technically speaking, because these claims survived, these claims are now not, any award under those claims should be her separate property and not subject to probate at all, or not, at least not subject to the decedent's probate. Right?
Thank you.
Thank you.
Judge Christensen Forster, you're muted in case you.
I was trying and I am muted. Now I'm not. Thank you, Mr. Jennings. Mr. Thayer.
We can't hear you. I can't hear you, Mr. Thayer.
Mr. Thayer, you're muted.
Sorry about that. Can you hear me now? Great.
Yes.
I think the essence of what I believe is in front of the court today are two very simple questions. Did the court err in deciding it had lost jurisdiction? And two, did the court err or abuse its discretion with respect to the Rule 25 denial? I think, Your Honor, that with respect to the judge's ruling, if you look at the ruling, and at the end of the ruling, and I think that's telling, goes to the jurisdiction question, the court ordered at page 8, for the foregoing reasons, and remember, Judge Griffin did a very careful approach to this. He invited the appellant to tell him why he should not close this case. She came to the court, she said why, and she filed a Rule 25 motion. And then, and we filed our objections. There was a hearing, and then the court entered the order. In this order, the court said that the objections were overruled. He said, I don't find them compelling. You've not given me enough reason. Now, be clear, she did not say, and she could have said, stay this case, let's stay the domestic case. I'm gonna create a probate action. She could have started a probate case anytime after August 3rd, 2020. Anytime she could have filed for probate. Yes, Your Honor.
Okay, can I start you with a question there? So, I mean, at the 1,000-foot level, the fight here is about whether we're in divorce court or whether we're in the probate case, right? And your view is that she needs to go to the probate case. If she goes to the probate case to try to get her assets, which is what you said she can do, what law would the probate judge be applying? Would it be applying the divorce code or would it be applying something else?
It would be applying Title 75, Your Honor, just like the bankruptcy court would be applying the bankruptcy rules and laws. This is analogous to that. And what the appellant is inviting this court to do is to gut that, to gut the process that has always been. And there's nothing in Title 30 that says that makes the point that, you know, this should be applied if someone dies. There's nothing about what happens if someone dies. Title 75 is all about that. Yes, Your Honor.
So what happens to child support? I mean, that leads me to a couple of questions. And the first one is, what happens to child support? If she has to go to probate case court,
It goes.
Sorry, somebody's not muted. But if she has to go to the probate case, and the divorce case is stopped at that point, who's deciding child support?
Well, the child support, Utah law is clear. Child support stops at the death of the payor. What happens though? What happens and what is happening? You should be aware of this. The appellant has filed as conservator of the child in the probate case to get her statutory allowance
outside the brief.
No.
I know what you want me to do, Your Honors, with that. I don't. So what the appellant as
evidence in the record, Mr. Mayor? Is that evidence in the record? Is that evidence in the record about the conservator?
I don't believe that is in the record, Your Honor.
Then please.
But there is I'll say this, that I think is in the record because the statutes are in the record, that there are statutory allowances in the probate court, Judge Tenney, that allow for different things for the minor child. So those are available for the minor child. There's various of them. And so she can avail herself through someone of those. So that's in the record. That statute is in the record.
I mean,
so Title 75 goes.
That leads to my question then, and I suspect the answer is inherent in the question. I mean, it's really something of a very almost radical position that you're taking, which is at the moment he dies, just the entirety of this thing goes away. There's no child support, there's no alimony, there's no distribution of a marital estate in the ordinary sense. Is it just entirely a probate action at that point? Did I have that right?
You have that right. And that's not my position in the sense that you may call it a radical position. That's the law. Alimony stops, child support stops, and then you can deal with the property issues as has been alluded to.
Okay, so then that leads to my final question, the sequencing. I understand now I had the first part of it wrong, but let's see about the last part of it. In an ordinary marital distribution case, in a divorce, as I understand what's happening is the husband is asking the court to say what part of the marital estate is his, and she's asking, and the wife is asking the divorce court to say what part of the marital estate is hers. And it just seems sequentially, and I think this is Mr. Jennings' point, it just seems sequentially like that would have to happen before we'd get into probate at all. That is the point of the probate action is to figure out which creditor has priority as to which part of his estate. Well, it seems like if she's going to have had the ability in the divorce case to pull stuff out of the marital estate first, it seems like that would have to happen first. What's wrong with that construct? Because I think that is their construct.
The reality is, one, that issue of what happens first, I don't think is in front of the court today, but the reality is the probate court takes all creditors. Once he dies, for example, the statutory liens hit, the federal IRS state liens hit. And in this case, we put in the record, it's millions of dollars in liens. Those take while the IRS is not a party to the case, their liens are imposed immediately. That creates a whole new element of who's in the case, who's in the game, if you will, who's potentially gets what.
Are they liens on him or are they liens on her?
They're liens on the entire estate.
Whose estate?
And what the appellant wants to happen, which has never happened, I've seen in Utah law, at least in the cases I've seen, where Title 30 is applied in the probate court. It just isn't done. The court will look at, and whether it's Judge Griffin, I'd agree with Judge Ord, quite honestly, that I don't think Judge Griffin really lost complete jurisdiction. And what I was getting to earlier, let me just make that point, was that he first overruled the objection. He then denied the Rule 25 motion. And then he said, the case is closed, and therefore I no longer have jurisdiction. That's what he actually did in his order. So with respect to that process, I think that was a reasonable process. Could he have kept it? I think he could have. But what would have happened? So I agree with Judge Orman. I think what would have happened, though, all of the creditors and the estate would have been banging at the divorce court's door to say, this has all got to be consolidated. The question of whether her claim survived, and let's be very clear in this case, Your Honor, and this is in her trial brief, Exhibit 3, in the court's transcript of oral arguments. I think it's important the court look at that, and it is at page 11, page 6, actually. Judge Griffin was confused at the oral argument. He thought he had made some rulings. In fact, he says on page 6, starting in line 3, my memory is I issued a ruling. My recollection is that I ruled that Miss Madura, meaning Miss Mower, that was counsel's name, was not a business tycoon, that she was educated but not experienced. And he said, I did not find that she had provided any material assistance to Mr. Mower's businesses. Therefore, I was not finding she was entitled to any of the premarital business property. And also in the appellant's statement of the record, they indicate that the stipulated forensic accountant, Mr. Brad Townsend, found the estate was worth $80 million and change. They also put in their statement of facts that Mr. Townsend, who was the stipulating accountant, the only one that testified as to the value of the estate, the marital estate was only worth $1 million and change. Her best case is $500,000, half of that. And she's got claims way beyond that. So let's assume she got a judgment in domestic court for that number. There still are multiple priority issues in the probate court that have to be dealt with.
Right, but I think their response to all of that, is in the probate court, those people would be fighting in line. They'd be figuring out a priority issue as to how to get to his assets. But what would have already happened in the divorce court is the divorce judge would have taken out of the marital estate what it would deem to be her assets. So why should she be having to fight with his creditors for property that was hers to begin with? That's their point.
Well, that's the question. That's the question, Your Honor. You've put the cart before the horse. No one has decided yet whose property is what. So I don't have a problem with Judge Griffin or a trial court judge in a domestic case looking at these issues, trying to decide, which is still an open question, we believe under Parenta, whether some of these claims actually survive.
Well, okay, but let me ask you a more targeted question then, because the divorce court issues the bifurcated divorce decree, and on the exact date in front of me, was it 2013? And it says that it's going to value the marital estate as of the time of the entry of the divorce decree. Let's just suppose, and I don't know if this is true, but let's just bear with me on my hypothetical. Let's just suppose that husband incurs a debt in 2016. 3 years later, if you've got that creditor in line in the probate court, he's fighting over a debt that happened years after she should have already taken her share of the marital estate out. So then what? If you're saying that the creditor is in front of her in line, what happens?
As I understand your question, Your Honor, I don't, until the court decides the issue of what's what, no one has a right to any of the property in that estate. The court's got to make that final determination in the domestic case.
The court already decided that when it issues a bifurcated divorce decree that says that as of 2013 that she's entitled to half of the marital estate. Isn't that exactly the finding that you're talking about?
I don't think the court found that she was entitled to half the marital estate. I don't recall a specific ruling.
The word half, but she's entitled to her portion. They're divorced as of that date, and then she's entitled to whatever portion of the estate that she would be entitled to under divorce law as of that moment. Why isn't that the answer to your point that you just made?
As I understand your question, Your Honor, and you're a little bit muffled, and I'm straining a little bit to hear you, but let me make sure I understand it, is that if the divorce decree enters, they get bifurcated in 2013, and then a couple years later, he passes? Is that the question?
If the court says you're divorced as of now, and then the court says, and we're gonna divide the marital estate and we're gonna value the marital estate as of now because now is the point at which you're divorced, and then some years later, the husband develops a debt. Why does she have to fight about who's in line about that debt that was incurred years after she was already entitled to some portion of the marital estate?
That's what the court will look at. The court will look at in determining other creditors and priorities, whether in fact that's her property and these other creditors should have any play in it. But someone's got to look at that. To now send this back to Judge Griffin and say, hey, decide all this first, that's a real practical problem because the probate case is in play, it's ongoing, it's moving forward. The special administrator, by the way, has no right to distribute any property at this point without an order from Judge Powell. So you're going to have conflicting rulings back and forth if this is not consolidated. And we don't generally have a problem with the idea of consolidation, but it can't be, our position is it cannot be consolidated absent allowing all creditors with all their rights. There are timelines that have run in the probate court. They decided to put all their litigation strategy in an appeal. That's what they decided in this case. Whereas they could have gone to probate court. They could have done some of the things this court is suggesting today, but they chose not to. So while they chose not to, statutory time limits have run in the probate court. And all of those rights, all of those statutes, all of those, if the court's going to consolidate, have got to be still in play. They can't be taken away by this court, or we just created another appellate issue. So I don't know if that's answered the court's question. I hope it has. Let me
Mr. Thayer, may I ask what I think is a related question? This case is somewhat atypical, although not altogether unprecedented, in that the marital estate is going to be a small part of his estate, in that this was one of what, 4 marriages?
Correct, at least, yeah.
He had a lot of premarital property. He had other marital estates in process and so forth. So out of his whole potential massive estate, there is a much smaller marital estate that is in play in the divorce case. And it seems to me that it's Judge Griffin who is in the best position to say, and you made reference to the $1 million figure. It seems like it's Judge Griffin who's in the best position to say, yeah, there's a big whole mess going on in probate court. Let me help you out a little bit by just defining what is the marital estate here, because it's not everything he owned. It's the marital property that arose during this comparatively brief marriage. That's what's before me. That's what I have jurisdiction over. And if Judge Griffin were to opine about what's to be done with that property, then the distribution, it seems, could be rolled over to the probate court, because maybe she does. Maybe she is in line behind the IRS and so forth. But I think it may be worth remembering that what Judge Griffin had before him is a fairly small piece of the pie that will be of concern to the administrator of the estate. Do I have that right?
I think that generally is accurate, Your Honor. I think that's why I was alluding to and referring the court to that transcript from the oral argument. He seemed to say that he thought he'd already ruled that she doesn't get the premarital stuff, which is the vast majority. Our position was it was the entirety. Even the forensic accountant found that 1 million. So it could be a very narrow question. And I think, Your Honor, that even if that is found, there will be an award of X dollars. There's no title to property, etc. And then it would be a question of priorities with all other creditors. There are a number of claims she makes: a retroactive alimony claim. There is a fees claim, though. So it's not just that narrow piece. And my concern is, Your Honors, and I'll be very clear with you, and if I can finish my answer since I've run out of time. My concern is that there may be valid objections. I don't know that there are, but I don't know that there aren't, that the special administrator might have, other potential creditors, certainly the IRS. And so I conceptually, Judge Orm, I think, Your Honor, that could work conceptually, maybe, but it's got to be very, very clear that no one else, that the other creditors have to be looked at in some respect. I think that's the real practical problem. While that appears to be narrow, if he decides that without the input from the other players, there could be some real problematic issues that create more appellate issues, as opposed to putting it all in one pot. One judge, everything there, looks at everything, and then you get one nice, neat package that comes up, because I'm confident it will come up, whatever the court rules below. Does that answer the court's question, Your Honor? Thank you. My time is out.
Could I just ask one question, though, and
please,
I get to because I'm the chair. A divorce court is a court of equity. A probate court is not, right? Does that play into where the appropriate, where those issues of valuation and determining what's equitable in a situation like this, does that matter at all?
I think, Your Honor, the probate court certainly has the right. It's a court of law and equity, and has the right to look at equitable claims. I think that's a little bit akin to the bankruptcy court, right? If you get, we see this a lot in domestic cases where someone files bankruptcy, and there are even property claims that one side claims an interest to, may be discharged or not discharged into bankruptcy court, but it's all subject to bankruptcy law and bankruptcy rules, etc. And there are some non-dischargeable debts or claims that one might find in the bankruptcy court. But the equitable question in this case, and I'm looking at 75-1-103 Utah Code, states, unless displaced by particular provisions of the code, the principles of law and equity supplement its provisions in Title 75. So that's the short answer to your question, Your Honor.
Thank you, Mr. Thayer. Any other questions? Appreciate your argument, Mr. Thayer. Mr. Jennings?
Thank you, Your Honors. I'd like to, I'm very happy that counsel made the analogy. Can you hear me?
Hold on one second. Let's start.
Oh, the timer's not going. Yeah, sorry. Okay. I'm happy that Mr. Thayer brought up the analogy to the bankruptcy court. I do a fair amount of work in crossover cases between bankruptcy and divorce cases. I lecture on it, and I've had many opportunities to deal with the judges in those cases, most recently with Judge Anderson there. Uniformly, what the bankruptcy court does, and to answer your question, Your Honor, Judge Tenney, there is a separate bankruptcy estate, just like this is a separate estate. And what they do, and Kevin Anderson does every time when we're in the middle of a divorce case, there's a bankruptcy, and there's a question about determination of the marital estate, which, because my client is not the decedent, right, any properties awarded to her in the divorce would be necessarily transferred to her. We don't have that issue in bankruptcy because no one's actually died. They've just created a bankruptcy estate. But they reserve it every time and defer to the divorce court to resolve the issue first before they come back. And the quote they give you again and again is, I do not want to be deciding retroactive alimony and child support issues in bankruptcy court. Okay, I'm going to let the district court judges who are better equipped and have heard the case deal with those issues. It's more telling than here where evidence is actually completed. We are done. And let's not ignore the fact that it was extended by over 2 years to get to the cusp, the precipice of a decision, which is also inordinate here. Mr. Thayer indicated that child support stops, alimony stops upon the death. Not true. There is still an absolutely
wrong on that. Yeah, I wanted to make sure
outstanding issue of retroactivity that was before the court. Retroactivity from the periods of time, because the court has discretion if they make a different finding at trial about what the incomes of the parties are, right, and the standard of living are certainly for alimony purposes. But with child support, it's squarely just income, right? And we had one full expert talking about the standard of living and how they lived that was unopposed, talking about a much higher standard. And Judge Griffin even commented on the fact that he, is strongly considering, and it was still an issue for him to decide, right? So I'm paraphrasing now, so forgive me. The issue of retroactivity, because he can go ahead and make those interim orders that were made at the first temporary order hearing in this case. Okay, he can alter the final award retroactive to the date of filing. Okay, now we're going to have the estate planning or the estate attorneys deal with that in probate court. And I think to your point, Judge Christiansen Forrester, and I'm not sure if your last name is hyphenated or not. It doesn't show on the camera, so I apologize if I'm being offensive. But they are sitting in a dual role, and equity comes in last there. Okay, and I don't think it's appropriate to have my client compete on the same level as all creditors in the same footing. What they do in bankruptcy court is defer the decision of what's going to happen in the divorce to the divorce court, so that the bankruptcy court has a clear idea of what the estate is. And those claims that counsel talked about, they don't automatically fall, and those liens fall, the day that he died. And certainly if they did, I would have gotten, and my client would have gotten notice from all these various creditors. She did not. Okay, because the estate that we're talking about is his probate estate. And that's the threshold question, is what is his probate estate? And throwing it all in one pot I can't think of a worse idea to resolve that. We now have to, and it would result in a bankruptcy court, probate court judge having to then go ahead and determine retroactively all these other issues. Now, even if it's consolidated in front of Judge Griffin, if by the very act of sending them all there creates new issues that Judge Griffin did not have to deal with in the decision that is already completed in his court about issues and questions of priority. These claims are held over clearly by the case law. The cleanest, most equitable way to deal with these issues is to have the divorce court finish its ruling, then let the probate court come in and divide up from that whatever is a part of his actual estate. That is the most equitable thing. And keep in mind the vast disparity in the parties' resources here. Okay, all this extra litigation, my client can't afford. She didn't get anything, and we put our claims in there, hundreds of thousands of dollars in fees. She's practically in bankruptcy herself almost on some of these issues. Hasn't. And they've been in probate now and for 2 years. And it's clearly their intent by their briefing alone. The briefing alone they submitted to the judge is to drag this out as long as possible and make sure that she ends up somewhere. Their claims will be to try to get her down to priority 5.
I don't know that that's fair to read into their briefing an intent to do that. I mean, that was a claim that you'd made in the briefing that they had ruthlessly litigated and so forth. And it just seems to me that parties are entitled to make their arguments as best they see fit, and as long as
I understand.
Okay.
And I'll withdraw that claim, Your Honor. Sure. And so I don't mean to say that, but again, it's clearly their position from their own written brief that she should be down somewhere in priority 5. And I'm sure they're going to continue to take that
It's a
position.
good faith basis for making the argument. I just, it's a quibbling point, but I don't know that we can infer from that any sort of nefarious intent, can we?
No, I'm not asking for that. I'm not asking for nefarious intent in any way, shape, or form. I'm just trying to point out an added level of complexity and difficulty in having these issues consolidated in a probate court that, in theory, shouldn't even have jurisdiction over these claims had they been had he lived a month longer, right? I mean, there's just a big due process issue here, Your Honor, and there is an equity issue here. The only court that squarely appointed the duty to deal with these claims from an equitable basis and this issue from an equitable basis is the divorce court. Do you have further questions for me?
Does not appear so. Thank you, counsel. I see that you're back, Mr. Thayer. Thank you for your arguments today. We will take this matter under advisement and we will render a written decision as soon as possible. So we will be in recess. Thank you very much.
Thank you, Your Honor.